I'm Matt Cohen, and this is a presentation that I've done a number of times in the past on considerations for people who work with children with disabilities in a clinical capacity in relation to both evaluation and report writing, and how you can conduct your reports in a way that will be likely to be not only accurate, but as impactful as possible in assisting the client in getting the services that they need. And at the same time, are strategically sound and ethically sound. So we're going to be talking about a variety of those different issues. But before I start to talk about that, I would be like an ostrich with my head in the sand if I didn't acknowledge, and in fact, I'm going to do more than just acknowledge, that there are massive changes occurring in the educational world, the mental health world, and the world in general as a result of Donald Trump being elected president and all of the other changes that have come with that, including Republican control of the Congress and the conservative control of the Supreme Court. And the things that are happening, and I'm doing, for some of you who've participated, I'm doing a whole training just on what's happening at the federal level and what people can do to respond against it, and at the same time, what people can do to try to protect kids at an individual level from both things that have already happened and things that are proposed or anticipated to happen in the next couple of years as the changes that are happening in Washington take effect to a greater and greater degree. And that's highly relevant to clinicians because you also can't operate in a vacuum, and your clients need, in many respects, far more from you now than perhaps they've ever needed before, because the likelihood is that rights are going to contract, services in terms of service mandates are going to contract, funding is going to contract, and even the available staff is going to contract within schools and governmental agencies to deal with the problems that people are facing. Could I ask everybody also to mute your phones or your mics, and then if you have a question at the end, you can unmute, but I'd like to just make it easier for everyone if we have mics muted for now. So there is, in my mind, a far greater need for good evaluations and good reports and good recommendations for kids now, and good support by clinicians for their clients now than it has been the case in the past. And I've been doing this for over 40 years, and I would say that we are at the tip of a crisis. It's already a crisis, and it's going to become even more of a crisis as we go along. And interestingly, because I've done the broader training on what's happening in Washington a number of times, a couple of people have raised complaint because they said, why are you fear mongering? Why are you catastrophizing about what's happening in Washington? And the answer to that, from my standpoint, is absolutely right. I'm catastrophizing because it is a catastrophe. And unless you recognize that, unless people in the country as a whole recognize it, the catastrophe is only going to accelerate and get worse. And so the more that we can do to inform ourselves, to inform our clients, and to push back and prepare, the more likely we'll be to both mitigate the effect of the crisis on the people in our lives and potentially be able to push back against some of these changes at the federal level. So this is going to be kind of a hybrid presentation where I'm going to cover some of that more broad concern, and then I'm going to get into a lot of nuts and bolts about how the special education system and the special ed laws relate to report writing. And sometimes clinicians don't really think about what the law says, and so they just do their clinical work, they do their clinical recommendation, they use tests and terminology that they know and feel comfortable with, but they're not aware of or not thinking about the context in which their reports are going to be received in the schools. And so the report doesn't really connect with or use language that's going to be effective within the context of services to kids and what schools pay attention to. So I guess the one other thing that I want to say about that is that uh, the for those of you who don't know me, as I indicated, I've been doing this for 40 years. I am heavily involved in working at both the federal level and at the state level in attempting to secure legal protections, maintain legal protections at the federal level, and maintain service levels at the federal level to whatever extent we can influence that. And at the same time, I am working at the state level to try to, in effect, ensure that Illinois and other states are doing everything that they can to protect services for kids at the state level, regardless of what happens in Washington. So it's kind of a multi-level effect. And in the context of doing that, I'm also attempting to empower both families and clinicians to do what you can that will make the most difference for clients in actual day-to-day service delivery situations. So that's the intention of all of this. And this is how to reach me. And by the way, this slideshow and video recording will be posted on our website, which is mattcohenassociates.com, within a couple of days. And so what I want to be talking about first is what's happening at the federal level that impacts kids with disabilities and the need for documentation. So the first thing that we know is that the staff of the U.S. Department of Education was cut by approximately 50%. And I'll talk more about some of the ways that those cuts have impacted kids with disabilities. But the most important impact of those cuts has been that roughly half of the staff of the Office for Civil Rights, which is the federal office within the U.S. Department of Education that's responsible for enforcing both Section 504 and the IDEA, is reduced substantially. The Chicago office of OCR, which covers many states in the Midwest, has been eliminated. A number of other major offices have been eliminated, and any and all complaints are now being directed to the remaining offices where there are fewer people and more demand for services. So even if there weren't any changes in priority or what cases they were going to do, there simply aren't very many people there to actually handle cases, which seems to be a pattern in the administration that just by cutting people, they can gut programs regardless of whether the program has actually been terminated or repealed. And make no mistake that even though the U.S. Department of Education hasn't been officially disbanded, in many respects, it's been functionally disbanded. And that's a concern for all of us, which I'll also be talking about. That's temporarily on hold because of court action, but the hold on the dismantlement is in many ways already effective because the staff were already released, and there's an appeal pending with the U.S. Supreme Court that may overturn the hold, and so it's very likely that the staff reduction will be maintained. There's also been a reallocation of Office for Civil Rights priorities, including shifting from race, sex, gender identity, and promoting, in effect, diversity, equity, and inclusion, and promoting the rights of people with disabilities, to focusing on eliminating DEI, focusing on alleged anti-Semitism, and concerned about anti-Semitism, but some of the things that are being used as a basis to say anti-Semitism are completely specious, and reduction in the number of cases that are being brought based on race and gender under Title VI and Title IX. And this is an example where actually there has been pushback from the disability community, and then the administration said, oh, no, we're not going to no longer do disability cases. We'll do disability cases still. And then that was out of one side of their mouth, and out of the other side of their mouth, they said that any program that refers to inclusion is under the umbrella of DEI, and that's subject to being terminated or even prosecuted. And then they went even further, and this is just unbelievable to me. They are raising concern about social emotional learning as an improper activity for school districts. And obviously, all of the folks on this call, or most of them, are involved with clinical services in one way or the other. Social emotional learning, it covers health and healthy mental health, as well as concerns about mental health. And despite the claim that they're concerned about mental health, they're basically saying that schools can't focus on that. So that Dear Colleague letter from February has threatened termination of federal funds to elementary, secondary, and post-secondary schools that are engaged in DEI activities. And just as an example, the Chicago Public Schools has already been targeted for that kind of investigation, focusing on any special programs or enrichment activities that are targeting any specific group, racial minorities, language minorities, not special ed services per se, but any program that overlaps with SEL, behavior, discipline, all those sorts of things are being potentially targeted. And the proof is in the pudding. Prior to the Trump administration, this past year, disability complaints for Office for Civil Rights accounted for 37% of all complaints. And in prior years, disability complaints were the majority of all OCR complaints. Of the top 100 OCR investigations that have been opened since January 20th, only 1% of the investigations focused on disability. So there has been just a profound shift in focus for the Office of Civil Rights. And that's not just relevant to the individual case or complaining party. If the shift of the enforcement effort changes, that gives a message to all of the schools that the enforcement effort is also going to change focus, and they're going to be more focused on making sure that they're not going to be threatened in terms of federal funds because they're actually providing separate bathrooms for kids who are trans, or access to athletics for a kid who's trans, or an access to a special locker room, or whatever those things are. Can't do that anymore, but they don't have to worry about any complaints about special education or disability because the federal government just isn't concerned about that now. There have also already been massive cuts in federal educational funding through the U.S. Department of Education Office of Special Ed Programs and related agencies within the federal government, including the elimination of almost $1 billion in educational research and technical assistance grants, claiming without proof that there's been waste and fraud that justifies those being eliminated. One area that is perhaps most significant for clinicians and evaluators is that they have reduced the funding or eliminated funding on data gathering about what schools are doing. They've reduced spending on research on what works and doesn't work. And perhaps most importantly to the educational community, the public, and clinicians, there has been a very useful federal operation through the U.S. Department of Education called the What Works Clearinghouse, which provides research-based information on which educational programs are effective and which educational programs are not effective. And that was available as a search engine. And as folks should know, that the IDEA requires school district programs to be peer reviewed to the extent practicable. And so now there is no easy access to what research is out there to support what school programs are research-based and effective, what school programs are not research-based at all, or even most worrisome, what school programs are have research, but the research shows they don't work very well. And clinicians, when they make recommendations, oftentimes they're making recommendations for things like a special learning disabilities methodology or a special intervention to support autism, like applied behavioral analysis or whatever. And those recommendations have much more credibility and impact under normal circumstances if you reference a research basis for what the recommendation is that you're making. But now it's going to be much harder for people to find access to that research base. But clinicians, as a request, the more that you can provide reference material that supports why a particular recommendation is justified from a effectiveness standpoint based on actual peer-reviewed research that's available, the stronger the case is going to be for the school to have to do that. And then in another indication of just how harsh these cuts have been, the administration just about a month and a half ago, announced that they're cutting $1 billion in mental health grants to schools. So these things are profound. The other thing that's happening that's of concern, and there have been in some ways more talk about this than action yet, but Project 2025 and the administration has made great criticisms of school districts for failing to maintain safe schools, and particularly for failing to deal with and appropriately disciplining kids who are having behavioral problems. Guess what? Kids with disabilities are far more likely to have behavioral problems than kids without disabilities. That's one of the reasons why special ed is so important, is because it recognizes that behavioral problems are frequently, if not always, but frequently a result of disabilities, and that the appropriate response is to provide more effective and perhaps more intensive programming to deal with whatever it is that's happening that's causing problem behavior, rather than just punishing and or excluding kids. So there's going to be more and more effort to both cut the data on what's happening with schools in relation to school discipline, and to cut the funding to promote positive behavioral interventions and supports, while strongly supporting the disciplinary exclusions that have in general ways proven to be ineffective and are often counterproductive. Just as an aside, I often talk about the fact that one-time suspension could be a test and might have a limited degree of efficacy in allowing the parties to sort out what needs to be going on. But if a child is being suspended repeatedly, that's actual pretty obvious proof that the suspensions are not working in relation to modifying behavior, and there needs to be a different approach. That's both practical and it's also legally required. And then another thing that's happening that's not specific to schools, but Medicaid is on the chopping block. Even as recently as this morning, there's discussion about what's happening in the Senate and the House in relation to limiting Medicaid. And it's clear, despite President Trump's statements to the contrary, that Medicaid and Medicare won't be touched, that the Congress is proposing extreme reductions in Medicaid. That hurts all people with disabilities who are covered by Medicaid, whether they're children or adults, but it has a particular impact for kids with disabilities because Medicaid is one of the major sources of funding for related services that public schools provide: social work, speech, occupational therapy, physical therapy, even, some of the testing that's done may be reimbursable under Medicaid, and that's a significant source of federal funding for school districts. So if that's eliminated, school districts are going to have less money to support those particular services. It's going to mean a hit on their overall budget, and it's highly likely that it will mean a reduction in access to services and services that are needed through the IEP process. And that will, by implication, mean that there's going to be even greater demand for services from the private sector for families, because they can't rely on the public school to provide many of the services that were previously available. Then I want to briefly cover some of the red flags that ought to be indications to clinicians and their client families that something is happening at school that reflects that things are occurring that are not based on actual student-specific progress or lack of progress, but are in reaction to changes in funding, changes in law, directives from the administration, and so on and so forth. So watch for red flags and encourage your clients to be aware of these red flags. The district is suddenly telling you that the child no longer needs some or any services, even without having any testing that actually documents that. The district suddenly expands or changes in-house programs that reduce options for kids and services. The district changes the allocation of shared or one-to-one aid availability and combines classes or shifts from individual classes to shared aids. They shift from direct service minutes to consult minutes, or from pull-out minutes to push-in minutes. And by the way, that's in many ways a scam, because when you do push-in minutes, typically schools would say, okay, the social worker is going to provide 10 minutes for Matt. And that's cool. But if the social worker is providing 10 minutes for Matt one-to-one pullout, that means one thing. But if the social worker is in class and is providing the services for 6 or 8 kids at the same time, they're getting, they're claiming that all of those kids are getting serviced, but it's only taking up 10 minutes of the clinician's time, and they're spreading that clinician out among many different people. Transportation may be made longer or eliminated. Kids are going to be doubled and tripled up in terms of travel time and number of kids on the bus. Class sizes are going to be increased, perhaps with increased requests for waivers to the State Board of Education. And many specialty or self-contained classes are going to be combined with other classes, whether that makes educational sense or not, just because they're trying to reduce the number of teachers that they need based on larger class sizes. So those are all just examples. That's not an exhaustive list, but if these things are happening, they're probably happening either because there are already budget cuts or because the school district is anticipating budget cuts, and so they're taking action to reduce the expenditure for special ed because there's less support coming in at the state and federal level. Timing is everything. If the district is recommending a change in placement or service level, the parent must request mediation or a due process hearing within 10 days to trigger something called the stay put placement rule. The stay put placement rule means that if they make that request within 10 days, the school district has to maintain the placement for as long as the disagreement or dispute is going on. And although parents are supposed to get copies of their rights from the school district, clinicians shouldn't ever assume that parents understand how these rules work. They're frankly very confusing for everybody, and especially for lay people. And if you're hearing about reductions in service, it'd be very important to be able to share information with your clients, whether it's based on what I'm saying to you today, or there are a number of different places that you can get this information, including from the State Board of Education parent manual, which is available on their website. So you have the right to a hearing, you have a right to mediation, you have a right to stay put if you request a hearing, and that even a change of label, a change of related service minutes, a change of access to paraprofessional support, those are all things that would potentially be frozen if a parent exercises their right under these circumstances. It does not apply to changes in goals or changes in grade level. Those are in effect institutional steps that are not steps that are programming changes for a particular child. And the forms to make a request for mediation or due process are on both the Illinois State Board of Education website and all of the other state agency websites if other people are on the call who are from other states. Evaluations and data and recommendations are more important than ever. So clinicians working with kids and families really have always been an important source of information for the family and for the schools. It's even more so now, as I indicated. Information is power. Inform yourself about the child's needs and functioning. The child should be evaluated at least annually by the school district, at least with respect to progress on their goals and objectives. There should be review of the child's educational records. Under some circumstances, the school district should be doing updated testing and getting parent input on how the kids are doing. In the state of the world at the moment, I'm recommending very strongly that rather than viewing the 3-year period that's typically seen as the normal cycle of evaluation and reevaluation, whether it's being done by the school district or by the private clinician at the initiation of the parent, I'm advocating that not that you have to repeat all testing every year, but that at least testing that's in the area where the child's disability is having the most impact, those sorts of things should be evaluated more often in order that you have current data to be prepared for any discussion that's happening. And the more that you have substantiation for what the child needs in the moment, the harder it's going to be to take away services. So to give an example of the point that I'm making, probably don't need to do fresh cognitive testing year by year as opposed to every 3 years, but it's probably going to be beneficial to be doing more frequent achievement testing and perhaps behavioral and emotional assessment on a more regular basis to see how the child is doing so that there's the immediate ability to push back. One of the things that happens often for parents is that they get kind of blindsided by moves that the school is making even before the current crisis. And then they go out and they try to find outside evaluations, and it takes them 3 to 6 months to even get an appointment. And then it takes another several months to get testing completed and a report written. And then so it may be many months, if not a school year, has gone by before the parent has adequate ammunition to assess, has the school made recommendations that make sense and are legitimate, or is the school district in some way missing, underplaying, or overplaying a particular problem to justify the outcome that the school is seeking when it's not really in the kid's interest. I'm strongly recommending that both clinicians and parents even more so than clinicians, put more priority on observing the child at school in order to both compare the test results to the real world results and in order to get more of a sense of what's happening environmentally, not just in the context of an evaluation office, but in the context of the actual classroom, to see how the child is functioning and what the school is doing. Do they have now many more kids in class than is either legally allowed, or whether or not legally allowed, good for this child? Is the child able to generalize the skills that they are able to show in a test environment into the classroom and social environment and so on? Have the child evaluated more fully, as I said, by both the school team and or by private clinicians. And then it's also important to encourage parents to go in and observe classes more often and volunteer at school if they can. All of these things are additional data, and data that may help to inform what they tell you as clinicians about in terms of what's happening at school, and can provide useful insight to help to broaden the available information that you're relying on. And as clinicians, I would also strongly encourage that when parents are indicating that there's some school problem, that you ask for the parents to provide copies of the IEPs, the school evaluation reports, and that you get behavior and other rating scales from the school district staff so that you have a legitimate basis to evaluate what's being perceived at school without just relying on either the parent's observation or the child's observation. Gesundheit. So what I would argue normally, but again, even more so under the circumstances, is that clinicians should be thinking about what is the reason for conducting an evaluation, and perhaps to broaden from kind of a clinical view that's in its own silo to a clinical view that takes into account all of the different settings in which that evaluation may be important, all of the different people who may be helped or informed by virtue of the results of the evaluation, and all of the different ways in which the data and recommendations in the evaluation may be used to either confirm that what the child is getting is appropriate, or if in one way or another what the child is getting is not appropriate, to help to provide direction to the parents, number one, and the educators, number two, and even other clinicians who are working with the child, number three, to target the interventions in a way that will be most impactful and effective for the child. So what's the purpose of the evaluation? Who's the audience? What is the goal of the person seeking the report? What is the goal of the clinician in responding? And are there potential additional audiences? One of the things that I experience as a lawyer, but I suspect it's not that dissimilar to what many clinicians experience, is that parents come in and they say, I think my kid's not making enough progress at school. I think my kid's struggling at school. Something is happening that I'm concerned about, but they don't know exactly what that problem is. They might say my kid can't read, but they don't know if it's a decoding problem or a fluency problem or a comprehension problem. They may say that my kid is having behavioral problems, but is that due to ADHD, or is it due to being bullied, or is it due to a child having some aggressive tendencies for a variety of different reasons? So it's important to know what's happening from the parent's perspective, but sometimes it's also important to widen the lens to try to identify all of the different possible things that are explanations for the concerns that the parent is raising, and all of the things that may be actually happening that the parent or educators may not be noticing, so that we're using the outside clinical involvement as a way of casting a wider net in terms of the things that might be potentially happening in relation to the child. Be aware of the different role and information for a clinician writing a report or a letter as the treating clinician versus as an evaluator. Clinicians have to make this judgment for themselves, but generally speaking, it's advisable that if you're an evaluator, you shouldn't also be a treating clinician and vice versa. Sometimes that's not possible, or there are reasons to do both, but it's useful to have those roles distinct if you can. And for, among other things, the evaluator is responding to data in an immediate and kind of more arm's length sense than the treating therapist, who may be getting very involved with and interacting with the child and family on a regular basis in the real world and having more information about what's happening from day to day. Distinguish the basis for information and the purpose of the relationship, and be aware of the impact of the report if you're the treating clinician on how that might affect treatment going forward, because of course it can. The clinician's role is to be an objective, neutral party, even if the treating clinician or retained by the patient as an evaluator. Part of the role may include advocacy, but you should not describe yourself as being the client's advocate unless that is an official role and title. In the context of schools and special education, the term advocate is a person who is retained to advocate. And if, as a clinician, you come to a school and you say you're there as the child's advocate, they will perceive you as having an agenda that's not the objective, neutral agenda, but rather that you are promoting an agenda against the school. And so it's important to differentiate. Even if
how many outposts here today?
Shocking, can you mute, please?
No.
I'm gonna have to do
Okay.
it.
That's too bad.
All right.
Nothing strikes me. Okay, bye.
Okay. Bye.
Okay. All right. You can just, I want to be clear, I'm not saying you shouldn't advocate. I'm just saying you shouldn't describe yourself as an advocate. So that's a matter of semantics in some senses, but it's an important thing, because if you describe yourself as an advocate in the school context, they will be likely to dismiss you and use that as a basis for criticizing you as a participant. Okay. Evaluations based on the federal law must be completed within school days of parent consent, unless you're in a state that has different rules. Once the parent makes the request, the evaluation needs to proceed. But if you're making a request and you're advising parents to make a request, it should be clear that they understand that making a request for evaluation is not the same as giving consent, unless the parent specifically says that in the letter requesting the evaluation. Okay. Additional assessment rules for schools and evaluators. Tests must be non-discriminatory. The test must test skills that are intended to be tested rather than something else. The most simple example of this would be that if a child is blind and they're being given a test that involves response to writing that's not in Braille, you're going to end up with them not being able to perform on the test. But the reason they don't perform is because they can't read the test due to their vision, not because of their ability to actually understand language. Testing must be in the client's primary language or mode of communication, must be administered according to the testing rules, and it must be competent to, the person testing must be competent to administer the test. That goes for the school district staff. It also goes for private evaluators as well. Additional assessment considerations include: don't make diagnosis or eligibility decisions based on one test or score. Distinguish facts from hearsay or impression. You need to distinguish facts from opinions. So if you get a result on a test, that's the score. Your interpretation of the result may be a professional judgment, but that's different than here is what the score said. identify sources of information unless confidential, and identify prior records or reports that you've reviewed. So your report should be describing full background about the information that was relied on. And again, it's very important as a private evaluator that if possible, you have access to the school's IEPs and that you have some way to access the school district staff's immediate assessment of the child's current functioning through the use of rating scales and the like. Tests must be reliable for the purpose for which they're being used. They even have to be reliable or appropriate for the age of the child. I've often encountered situations where a test is being used and there's nothing wrong with the test, but it wasn't intended for that age group. Tests must assess the relative contribution of cognitive behavioral factors in addition to physical or developmental and environmental factors. The child should be assessed in all areas of suspected disability by the school district and by the private clinician. I had a report just recently where the evaluator did a great evaluation of whether the child had autism or not, but simply didn't look at the question of whether the child also had ADHD and a learning disability. And it turned out that the child had both, but the parent then had to go back and get additional testing, even though, even in the test environment itself, there'd been indications that the child had difficulties in those areas. And so that's a place where there may appropriately be dialogue between the clinician and the parent to say, hey, I think your child, even though you came in for X, these other things are probably indicated as potentially present, and we ought to do a broader evaluation. Evaluations are supposed to be non-discriminatory, and they're supposed to be provided in the language and form most likely to yield accurate information on what the child knows and can do academically, developmentally, and functionally. And by the way, this knows and can do academically, developmentally, and functionally, again, encourage that for private evaluators as well as school evaluators, what they can't do as well as what they can do. And the reason this is important is it encourages not only a focus on the child's deficits or challenges, but a focus on identifying what are the areas of strength so that you can build on the things that the child is actually good at in relation to others, or at least good at in a relative sense, even in relation to their weaknesses. And this is a huge concern, the law was amended 15 years ago to add the requirement for functional performance. And schools now do maybe a little tiny bit of their evaluation relating to functional performance. Clinicians, in every way that you can, please try to get a good feeling for what the child is able to do, both through testing and by observation. Give an example of this. I have an evaluator who I don't think is on the call, but who I respect very much in the Chicago area. And she was evaluating a child with Down syndrome and some significant areas of cognitive weakness and considerable academic difficulty. And at the end of the evaluation, which based on the standardized testing or formal testing was indicating he was going to come in pretty low, she noticed that he was looking at the Apple Watch that he had on, and he was reading and texting. And it turned out he was reading and texting messages from his sibling who was working out where they were going to go for lunch after the testing was over. And obviously, the fact that he could read and respond to the sibling through texting was incongruent with the information that was on the test. But that was like a big heads up that the child's ability to perform on the standardized test was not necessarily reflective of what the child was able to do in other settings. And that actually caused the clinician to step back and consider the need to do some other ways to assess the student that might be either more accurate or at least more balanced and holistic. It needs to yield accurate information. If you don't make yourself aware of and assess how factors may be occurring that interfere with whether the results of the testing are accurate, you're going to get a skewed result. I once had a school district that evaluated a child in a testing room that had a big window looking over the playing field with a lot of trees, and it was stormy that day. And the child kept looking out at the storm and at the leaves coming down, and they reported the child as being getting a very low score, but he had ADHD and he was being given time tests. And of course, he was spending much of the test time being distracted. So it was questionable response. Needless to say, that evaluator did not stand up well under my cross-examination. So be conscious of what the different things are that may affect a performance. Okay, we're going to skip that and just keep moving. Link clinical data to observation data and anecdotal reports, and I've already given an example of that. Use observation in the school and test environment as much as possible. Strongly encouraging, as I said, parents to go in and observe, even more so than in the past. Strongly encouraging clinicians to go in and observe. If you're a psychologist doing formal testing, that can be very helpful. If you're a social worker or other mental health professional, very helpful to see what's happening. Speech therapists, OT, all of these professionals can benefit greatly from seeing what's happening in the school. And sometimes people say to me, well, the kid knows me, it's not going to be a realistic assessment or observation. That's true, but you'd be surprised at how much you can see, even though the kid may know you, or the person may say, well, we think that the school is going to sanitize the environment, not give us a real sense of what's going on. One of the ways that they do that, by the way, is they have you go on and observe for PE or something like that. It's very important to target an observation for the subject matter that you are concerned about. But oftentimes, in my experience, a careful and sensible observer can get all sorts of information, even if the school is in effect prettying up the environment to make it seem like the child is either doing better or that the school is doing better. And by the way, and this is to put it very bluntly, when I'm looking for private evaluations, the number one concern is that we're wanting to learn about the child and evaluate the child. But I would argue that the evaluation is also an evaluation of the school. And it's very important for you to think about, how does this child function in the different environments? Obviously, you're not there to do unless you're a family therapist or doing a custody evaluation, you're not evaluating the family per se. But if there are things that are obvious about whatever the environments are that the child is in that impact their functioning, that should be things that you're paying attention to in your report. And in the context of school, that's something that should be very much addressed in terms of both the findings and recommendations. I have evaluators who feel very uncomfortable with that. I have evaluators who are able to say, look, I looked at the kid's IEP for 3 years in a row, and it was the same goal and same goal level, and their test results didn't show any progress. So even based on their own data, I'm concerned this child isn't making any progress. And I'm also concerned because I understand that IEPs are supposed to be modified to promote progress. If they're not changing things in light of data that's showing no progress, there's something wrong with how the school is programming or using the IEP process. Link the test data to school reports such as report cards, progress reports, behavioral records. Schools now use these curriculum-based measures and little spot tests and very, very narrow cherry-picked data points to assess how a child is doing. It's not uncommon for a parent to come to me and say, the school district says my child's reading or writing fine, and then they come home and they can't read a thing. And when they write, it looks like they, I can't read their handwriting and they're not able to barely even write their own name. One suggestion for you and for parents that I would make in those situations is use videotape, but have the parents save the work samples. Clinicians have them provide you with work samples. Have the child do some actual work samples, even if they're not specifically called for in the test instruments you're using, so that you can actually say, hey, the school's reporting X, that was in the IEP documents or the evaluation reports, but here in my office, that wasn't happening. And you know why this is so powerful and important? This is somewhat obvious for you as clinicians in what you're trying to do. The entire point of special education is the generalization of skills that a child can make progress that leads them towards independence, or as much independence as possible when they're out of school. If the child is doing it in a particular setting and they're not able to do it somewhere else, that means that generalization is not happening. And so even if the school isn't lying about the child's progress in a controlled environment, let's say with a 1-to-1 aid or 1-to-1 on with the teacher, if that skill isn't carrying over, not much use. If they can't go to McDonald's and use the basic mental math that they're supposed to be working on at school to actually figure out how much money they need and whether they got the right change back, not working. So be very, very aware of the functional skills and whether there's progress occurring on those functional skills. Reevaluations are required by law through the school district every 3 years, unless either the parent or the school requests an evaluation more frequently than 3 years, which can be done. Though if it's the parent request, the school has to say yes or no. And if it's the school request, the parent can say yes or no. But the important thing that schools often do that I have great concern about is that they will say at the 3-year point, well, we're just going to do a records review because, oh, this child has an intellectual disability, nothing's going to change, or this child's learning disability seems the same, or, well, this child's still depressed, so, there's nothing more that we really need to do to test. And I say wrong, wrong, wrong. The testing can either reveal progress that's being shown that may not be observable to the school staff, or lack of progress that may not be observable to the school staff. It may reveal that there's actually been a failure of diagnosis, and actually this child has additional or different disabilities than have been identified in the past. It may indicate that the child is actually struggling mightily, and the school isn't really noticing it because they're just in kind of a perpetual momentum. In some ways, some of the saddest cases are cases where the school says this child either has very low IQ or they're nonverbal or something like that, and they're not using the right test to assess all of the child's capabilities. And so they're basically programming the child in a way that ensures a lack of progress because they're not providing them the input that would be needed to give them a chance at developing appropriate language and academic skills and so on. So I have a strong feeling that retesting is generally a desirable thing, at least every 3 years. And again, given the concern about what will be happening with federal law and funding, that ought to be something that's considered to be done more frequently. Parents have a right to participate in the determination of which areas to test. If the school proposes to do less than a full reevaluation, they say, we just want to do a records review, or we're just going to assess in this one area. This is one of the places in the law where the parent has an absolute right. And that is that if the school is recommending less than full reevaluation and the parent says, we want full reevaluation, the school is legally required to do full reevaluation in the areas that have been tested previously. So that's also something for parents to be aware. And by the way, as private clinicians, if your client has financial issues, one strategy would be to say, well, let's have the school do a certain part of the testing, and then we'll do the things that the school is not likely to do, and we'll also review the school district's testing so that you can conserve the parents' resources, but still be able to get meaningful information yourself to form a legitimate clinical judgment and make useful recommendations. I've already really talked about why to do reevaluation. Independent evaluations are always things that parents can choose to do at their own expense. Many parents are aware, many are not, that if a school district does an evaluation and the parent perceives that it's not adequate, the parents have the right to request an independent evaluation at district expense. If the district feels their evaluation was appropriate, they then have to request a hearing against the parent to prove that their evaluation was appropriate. I think independent evaluations are enormously useful, and we suggest them in the significant majority of the cases that we get. But I think that independent educational evaluations, unless the school and the parent can mutually agree on an evaluator that they both trust and feel comfortable with, and on what the evaluations will be, to have a big fight about whether the school district should pay for an independent evaluation, the parent is going to lose huge amounts of time for the kid while that fight goes on. And there may very well be as much or more money spent on fighting about an evaluation than actually having it done. In a case that I've got going right now, we agreed on a mutual evaluation with the idea that each side would suggest evaluators. Several of the people on this call were suggested by me. The school district made a number of recommendations. The evaluation has been the discussion over evaluator has been going on for 6 weeks, and we still haven't agreed on who the evaluator could be. And it's very likely that the agreement is going to be neutralized because we can't agree on an evaluator that everybody feels comfortable with. So independent evaluations, if the family doesn't have any money, yes, it's good to force the school district to try to pay for it. But if there are resources, I would recommend that families just do it on their own. And by the way, for both the parents and the evaluators, if the school is paying for the evaluation, then the school has a right to be equally present, and you're accountable to them as well as the parent. If the parent's paying for it privately, then you have a private relationship with them. And in my experience, that has some advantages in terms of interacting with the school. Be mindful of diagnostic ghosts. Labels may be useful at one time or setting, but have negative ramifications for the child in other settings. For example, just a very quick example, and in the world of autism, I frequently am told by families, gee, we heard that if you get the label of autism, you get any services that you want. And so that's the desired label to get. That's like the golden ticket to getting good special ed services. Well, I don't agree with that at all. And in fact, in my experience, it's not uncommon in school districts that a child, and we recognize, by the way, that autism is a spectrum disorder, which means that there are kids with very widely ranging areas and levels of ability, that the autism services that school districts tend to deliver are grouped. So all of the kids with autism get the package of services, despite the fact that there may be wildly different communication abilities, behavioral levels, and cognitive abilities. And so in school, I'm not a big fan of saying just anybody who has autism is going to be best served with the autism label. There may be other ways for them to get the help they need without that label. But on the other hand, unquestionably, when you reach adulthood, the autism label opens up all sorts of government benefits as kind of an inarguable basis for government benefits that is very helpful. So I use that just as an example to say that the labels make a difference. They may open doors. They may also result in unintended consequences as kids are tracked based on the label rather than who they really are. Diagnoses: be aware of the differences between clinical and legal or institutional labels. Autism is an example where the educational criteria are different than the clinical criteria. And I'll talk more about the criteria in a second. Be aware of the audience that the report is being primarily directed to, but also where the report might end up being used, where you didn't really think about the consequences. Be aware of language like the patient has symptoms of, the patient fits the pattern or profile of. As long as you're clinically competent to make a diagnosis, saying that the patient fits is not the same thing as this is the diagnosis. And school districts sometimes say, well, we don't actually see an official diagnosis, so we appreciate the input, but we're not going to regard it as having the same effect on our decision-making as it would if there was an actual diagnosis. And then the other place where and by the way, if you're not certain, it's okay that you're not certain, but then explain why you're not certain. And then the other place where I oftentimes come up with difficulties when the clinician has a rule-out diagnosis. I understand why rule-out diagnoses are given, but the rationale for the rule-out diagnosis is often not provided. And oftentimes the rule-out diagnosis is specifically intended to be a trigger for the child being evaluated at a later date when there may be more data or more developmental progress or lack of progress occurring that would make it easier to assess. We recently had a case where the child was assessed for autism in first grade, and the evaluator said, well, there are many symptoms of autism that are possible here, but the child's too young and I don't see enough symptoms to actually make the formal diagnosis. I recommend that the school evaluate him a year from now to see whether the diagnosis is warranted. 7 years later, the school district still had not evaluated the child for autism, despite the fact that he was showing more and more symptoms and more severe symptoms of autism. And finally, the parent went out and got a private evaluation. He was absolutely meeting criteria for autism. And there'd been 6 or 7 years of programming that would have been informed by that diagnosis if it had been made in a timely way. So okay, rule out, but try to put as many stipulations and explanations into that rule out as possible so that it doesn't just get lost in the weeds. Compare and contrast prior school and private testing. I do that. I'm not a clinician. I'm not always sure I'm doing what's clinically supportable, but numbers seem like numbers. The more that you can show progress over time, either positively or negatively, or that the child's functioning is static, all of that's oftentimes very important. And it may be the trend is as important as the fact of the condition being present, because part of the reason for testing is to assess what treatments are appropriate and are treatments that are being used working. And so if you're not making a comparison over time, but simply viewing it as a snapshot in isolation, going to be much harder for the parents or even for you to assess, are the interventions, whether they're public or private, actually having a beneficial or of concern, a detrimental effect on the child. So review prior records, evaluations, clinical reports, etc. The IDEA has 13 categories of disability. The child has to meet one of the 13 categories. But then, and here's something I want to raise as a big concern for something that clinicians oftentimes don't seem to be fully aware of. To qualify for a 504 plan, it's enough that you have a physical or mental impairment, and generally identified by a clinician. It doesn't even have to be by the school, that substantially limits one or more major life activities, including thinking and reading and learning and so on, and that requires some form of accommodation or support. Very much a wider range of things that qualify for a 504 plan. But to qualify for an IEP, the school has to see evidence that the child meets one of the 13 categories, and there are separate criteria for each category. The disability has to adversely affect educational performance, and I'll talk a bit more about that in a second. And the student must need special education intervention, which means intervention by a special ed teacher, not by a related service provider. And so first, with respect to adverse effect on educational performance, schools often are inconsistent about how they interpret that word. If a child has good grades, but they're setting fires in the bathroom, they're probably going to say that's an adverse effect on educational performance. But if the child is withdrawn, isolated, but not a behavior problem, and they're getting adequate grades, I've even had kids who are at the top of their class academically, but they're having anxiety attacks, they're spending time every day in the nurse's office, they're throwing up before they go to school and so on. The school says, oh no, that's not an academic issue because their grades and achievement test scores are fine. I would argue that those kids are also experiencing an adverse effect on educational performance. And from a clinical standpoint, to be clear about that, the child's emotional problems are related to their educational functioning. And if they're having anxiety or depression or esteem issues or social interaction issues at school, those are also part of the school mandate. And if you need a source for that or sources for that, one is that the state has what are called social emotional learning standards. And those are all things that are required for all kids, like being able to develop appropriate social relationships and being able to participate in a group and so on. And so that's a very powerful source to say, hey, you may not be seeing it in grades and achievement test scores, but here are the other ways it's showing up. And then the second way it shows up is look at the kids' report cards, because the report cards frequently, if not all school districts, but generally speaking, and all the more so for kids that up through, let's say, middle school, but they have it in various ways in high school. Not only do they have an academic grade, but they may have social behavioral grades or at least social behavioral comments. And those things also reflect that why is the school even recording this unless this is relevant to how the school is assessing the child's functioning at school. And by the way, back to my earlier point about generalization, all of these things that the school is supposed to be working on are intended to address whether the child is able to generalize the skills in order to achieve greater independence when they graduate. And another place where you can, by the way, make the case about that is that schools are required to develop transition plans for children aged 14 and a half and above that are geared to promoting their independence and ability to achieve post-secondary goals. Post-secondary meaning that the child is able to successfully accomplish the things that their parents, and the school identified as realistic post-secondary goals. So the arbitrary distinction that grades and achievement test scores are the only basis of disability or the only basis for certain forms of intervention. It's just not legally correct nor practical. And you can be a very important part in making the case for why that distinction is not correct. Okay, so the categories are there. The label is a ticket into the system. It is frequently in the real world a ticket to a specific package of services, but it's not supposed to be that the label equals a service plan. It's supposed to be that the label gets you into special ed, and then you identify the child's needs on an individual basis and develop a plan that's responsive to the child's needs on an individual and unique basis. And in fact, there's even a requirement that the school address both the direct and indirect consequences of a child's disability. So let's say the child has a reading disability, but because they can't read, they have very poor self-esteem. They may not be diagnosed with an emotional disorder, but nonetheless, they have a functional problem of low self-esteem arising from the learning disability, and that should be addressed as well. Don't forget the other two criteria. The presence of the disability is not enough. You have to address the adverse effect, and you have to address the need for special education intervention. As I indicated, the educational performance should be broadly construed. The fact that a child's getting A's but is spending all day in the principal's office is not irrelevant, but highly relevant to whether the child is in fact having an adverse effect on performance. Does the child need special education? Special education is defined as specially designed instruction, including adapting as necessary the content, method, and mode of delivery of instruction. But for purposes of qualification, that isn't intended to be that it's done by a regular ed teacher without the involvement of a special educator. It needs to have some role for a special educator. And frequently I have clinicians who will say, child needs an IEP, but the reason for that is they need extended time on tests, and they need preferential seating, and they need a hallway pass, and they need maybe audiobooks, let's say. Those are all accommodations. You don't need a special education teacher for those accommodations. And if all that the evaluator is recommending is accommodations, I guarantee you what the school is going to say is 504 plan, 504 plan, 504 plan, not IEP. Why does that matter? Well, number one, you may be missing some supports that are very important for the kid. And number two, without going into great detail, as a general matter, there is more accountability with an IEP than there is with a 504 plan. So all things being equal, I would say it's generally preferable for a kid to have an IEP than it is for a 504 plan. But then in my experience, and I'm just a poor country lawyer, but I go back to the clinician, I say, well, why didn't you recommend an IEP? And because they said just a 504 plan, they thought accommodations. I said, well, conversely, you recommended an IEP, but I don't see any instructional recommendation. They say, well, the kid's bright. I don't think they need special ed. Well, the assumption is that special ed is a place that you go in a special ed room, and perhaps even for the whole day. And schools often cherry pick that, and they'll tell parents and clinicians, oh, if you want special ed with an IEP, then we're going to put your kid with those kids. And that's an all or nothing proposition. One of the things to be aware of are there are many ways that special ed might look and be delivered. So that can include what's called a resource room or a study strategies class that's supervised by a special ed teacher that may occur once a day. It may occur once every 2 or 3 days. It may occur once a week. It could include a co-taught classroom where there are both regular and special ed teachers in the classroom. It could include what's called push-in service, where the special ed teacher comes into the classroom, let's say 20 minutes a day, 3 days a week. It could include a check-in, check-out, where the child visits with a special ed teacher at the beginning of the day, at the end of the day for 15 minutes, or even just for 15 minutes at some point during the day. It could include the special ed teacher as a consultant to the regular ed teachers. So there are many different ways that special ed can be identified, but you as an evaluator, you're probably not helping your client as much as you intend to if you think that they need an IEP, but you're not spelling out what the role of the special educator is. So it's very important to detail that. And as the understanding of executive functioning gets broader and broader, and we understand that it has all sorts of emotional and behavioral components. There's a lot of talk about executive functioning. Educators may have limited knowledge of what what executive functioning involves, and so they say, okay, we'll provide a graphic organizer, or we'll provide an app for the child to do X or Y. They don't teach how to use these things, and executive functioning skills can be taught. And so that's, if you're looking for ways to address the role of a special ed teacher, that's one of the things that you can suggest that they do, that will provide a discrete role for the special ed teacher, even if within the academic content areas, the child is going to be generally competent. The LD dilemma, the discrepancy formula is out as of 2004. In fact, it's not really out. Schools and clinicians should use the discrepancy formula still as a functional thing, even though the state criteria don't really focus on it. But although they don't focus on it as the primary determinant of eligibility, the fact of discrepancy between potential and performance is still part of the federal regulations, and so it's still useful. And then I would emphasize looking at functional performance and looking at generalization. The schools do, again, all of these things like the Ames Web or the MAP testing, NWEA testing, and other sorts of testing to say, oh, the kids at or approximately at grade level, but they're not drilling down into specific skill areas to see how the child is actually doing on specific skills. And don't forget real world observation. So despite the rumors that made neuropsychological testing seem like it was no longer relevant to school decision making, in my judgment, it's more relevant than ever, and very important in second opinion type of situations where the school is not making appropriate judgments on its own. Schools may not focus predominantly or exclusively on academics, but must consider all areas of the child's functioning. Equally important for private clinicians to do it too. By the way, I don't want to just focus on the test element here. Therapists, whatever kind of therapist you are, also have all sorts of information about the child that can be very relevant to what the child needs, including behavioral observations about their attention span, their emotions, their mood, their ability to maintain regulation, their likelihood to be reactive to sensory stimulation, and so on. So, and my suggestion to parents is always, the more clinical input you can have, the better. And it's not that there's one evaluator who's magical. Any evaluators or clinicians who you have working with the child are an important source of information. The IQ glass ceiling, IQ is a huge part of our society, and it certainly has its place in some circumstances, in some ways, but it's not, it should not be the sole determinant of who a child is, even in the context of evaluating intellectual disability. The standards for evaluation of intellectual disability make clear that evaluation of functional performance is as important, if not more important, than the use of IQ scores. And as I've experienced many times with my clients, the testing doesn't always accurately measure the things that are going on with the child that may reflect either their deficits or their abilities. Circumstances may impact test performance, and my inclination would be that people should err on the side of, just need to mute somebody there, err on the side of, if there's any uncertainty about the child's testing, and I know many clinicians do this carefully and clearly, that this is an underestimate of the child's potential, that should be stated, and or the circumstances under which the child was evaluated were not such that we could get a full assessment of the child's abilities. Special area of concern is the area of socially maladjusted and emotionally disordered or disturbed. Kids qualify for emotionally disturbed based on a behavior unless the behavior is due to social maladjustment. And this is like a Mobius strip or a catch-22. because ED behavior is all subjective. Inappropriate thoughts or feelings under normal circumstances, inappropriate relationships with peers or adults, inappropriate thoughts or feelings. Those are pretty broad terms. If I look back on my life as an adolescent, if I'd been come up after these rules came into place, I have no doubt that as a teenager, I would have been identified as ED. I would go so far as to say many adolescent boys would meet the criteria for ED and perhaps some adolescent girls. But in any event, be careful that the ED criteria are highly subjective. If you're not conscious of it, the BASC, which is one of the most frequently used rating scales in the United States for determining kids' behavioral issues and needs, the BASC was specifically developed to correlate to the criteria for ED in the special education law. I'm not a scientist, so I'll just say this as a layperson, but if you've written a test to correspond to a certain set of criteria, it seems predictable that it's more likely that the criteria, the data that you get in response to the test is more likely to fit those criteria. So picking which test instrument or rating scale you use can oftentimes predetermine the outcome. And the social maladjustment escape clause for schools, basically it's saying the kid has a conduct disorder. Frankly, and again, I'm not a clinician, but I have a high degree of concern about the use of conduct disorder for any kid, and I've been involved in litigation to challenge its use, which I find to be highly racially discriminatory based on socioeconomic status and so on, and really just an escape clause to label kids based on behavior and push them out of school. Similarly, though, if I think about the different disability categories, the ED category is a highly stigmatizing label. And although these labels are all necessary in order to access special education, try to identify the diagnoses and labels that are appropriate and fit, but are the least likely to cause harm at the same time. And there are, particularly in relation to ED, there are possibilities for kids with anxiety, kids with depression, kids with various things like bipolar. You may be able to see the kid identified under the other health impaired category rather than under the ED label. And you can still recommend a variety of services clinically or from the school's mental health side to address that label, but without them being tagged in quite the same way. And again, that's also concerning because although schools are not supposed to use the label to group or program for kids, frequently that's the way it works out. And so labeling kids and then having the kids with emotional behavioral issues, which also is a very wide spectrum, often leads to grouping kids who really have very dissimilar social behavioral profiles. Other health impairment includes conditions such as asthma, diabetes, seizure disorders, attention deficit disorder, sickle cell anemia, which result in limited vitality, strength, or alertness, including limited alertness to educational tasks due to heightened alertness to environmental stimuli. And by the way, that's including but not limited to. That's not an exhaustive list of the health conditions. So just because those are the ones there doesn't mean that those are the only ones covered. What about labels that don't fit? Sensory integration disorder, sensory regulation disorder, apraxia, pathological demand avoidance, sensory processing disorder, nonverbal learning disability. The fact that there's not an explicit label contained in the law doesn't mean that the child can't be covered. You just have to find a way to make those symptoms fit within one of the categories of disability that are there, including we use other health impairment a lot. You could use multiple disabilities as a category. Pathological demand avoidance can be a feature of autism. Sensory processing disorder could be a function of other health impairment. Apraxia could be under the speech and language category. So don't allow the fact that you don't see the words of the condition itself within the set of categories doesn't mean that they can't be identified. There are many things that are continuing disputes, like when to use other health impairment, is ADHD a legitimate diagnosis, are motor and sensory issues a separate basis for eligibility, disputes over who evaluates and pays for evaluations, whether a child should qualify for an IEP for ADHD sensory and motor concerns, disputes over whether high achieving kids with disabilities are entitled to an IEP or a 504 plan. A most extreme example, I had a parent who came to me, their child was a senior. He was at the top of the graduating class in terms of GPA, and the school was going to graduate him a week later. And he had absolutely terrible executive functioning skills, couldn't figure out what materials he needed, required a high level of prompting, reminding, and et cetera, in order to get things done. But he was very smart, and so he still was able to get great grades. We actually blocked the student's graduation, and we were able to work out, I think it was a year of one-to-one executive functioning support to help him to learn the executive functioning skills while he started out in a community college program, to position him to be able to have practice so that then when he went on to college, he'd be more able to function. If the child has been referred for special ed and determined ineligible, the team should automatically consider whether the child will meet the broader categories or criteria for eligibility under Section 504. Don't assume that a child can't qualify for an IEP without thinking through the criteria, as I said earlier, but don't assume because a child doesn't qualify for an IEP that they also don't qualify for a 504 plan. The universe of kids who qualify for a 504 plan is far broader than the universe of kids who qualify for an IEP. I've already talked about the criteria for 504. What is good about 504 eligibility? Well, it's better than nothing. It may be less stigmatizing than having an IEP or being in special ed. In some school districts, special ed is a fairly intractable bureaucracy with very heavily siloed service delivery systems. 504 tends to be focused on kids who are being served within regular education. And although the special ed law requires kids to be served in the least restrictive environment, sometimes that's an afterthought or done by formula, whereas 504 kids are based in regular ed as a general matter. Students are still entitled to receive a free appropriate public education with a 504 plan, then though it's less, it means different things than it does under an IEP. There are various ways to enforce a 504 plan under federal law, though at this point I would have to say, and I say this to our clients, filing a complaint for violations of 504 with the Office for Civil Rights, in my personal estimation, is right now a dead end and a waste of time. And again, there's an easier threshold of eligibility for 504 than there is for an IDEA eligibility or for an IEP. So many kids can be served and get the help that they need under a 504 plan, though they aren't going to meet the criteria for an IEP. It's also helpful in making the case for accommodations on ACT, SAT, and testing that the student may need when they go further in college or graduate school, MCATs, LSAT, licensing exams, all of those things. By the way, we do provide advocacy services for kids who have denial of accommodations under any of those test circumstances. And having good documentation, whether it's an IEP or a 504 plan, does not automatically guarantee you'll get accommodations through the test agencies or the college or university, but it sure helps. 504 plans require documentation of impairment in various ways, but as I say, the prior documentation of having been provided accommodations helps, though it's not necessarily dispositive rather. This is true not just in relation to 504, but special ed also. Importance of records review. There is all sorts of data in the records that can be useful for you in both making a full and accurate diagnosis, in evaluating what treatments and interventions have been used to support the child and whether those have worked or not, and in developing recommendations that are going to be meaningful for the child going forward. Explain how splinter skill impairments impact functionality in relation to specific tasks and in relation to the need for accommodation. And if you're unsuccessful, then you need to pursue further means through either a special ed or a 504 hearing process, though we try to work it out as much as possible without that if we can. Just an example of either splinter skills or how school testing versus private testing can make a difference. It's quite common that schools will give an IQ test and an achievement test, a broad achievement test like the Wyatt or the Woodcock-Johnson or the KTEA, and that shows that the kid's doing okay. They may have weaknesses in certain areas like reading, but it's not in the impaired range. But they don't do more detailed testing. Again, I'm not an evaluator, but just as an example, when parents are reporting and the kid is reporting frequent reading problems and the broad testing that's been done doesn't provide enough data to identify the presence of a reading disability, certain specific tests like the GORT, like the test of word reading efficiency, and like the CTOP, the comprehensive test of phonological processing, that's my secret weapon actually in trying to identify kids with learning disabilities, because I frequently see kids who didn't show up as meeting criteria based on the school testing, and then they do the CTOP and they have areas of processing that are highly impaired. And I'm not saying that as an expert on testing, but just I see that testing is frequently low even when the broader achievement testing is higher. Tie recommendations to underlying assessment data. Tie recommendations to the accepted research-based strategies to the extent that you can. It's even helpful to provide the actual research that you're relying on to say ABA should be provided, Wilson reading should be provided, Lindemuth Bell should be provided, positive reinforcement should be provided, a AAC device should be provided. Whatever it is, the more that you can provide both the results of your personal evaluation and the information that supports why the particular intervention that you're recommending is appropriate, that's going to help go a long way in providing ammunition for the parents and their advocates to get what's needed. Frame recommendations in the context of legal standards governing the situation. So here's number one rule for clinicians and parents when they come to see me or I talk to them. When you're making recommendations, clinicians and parents are almost universally inclined to say, what's best for the child? The special education law requires schools to provide what is necessary for the child, not what's best. And so when parents say, I want what's best, the school says, well, that's great. I understand why you want that, but that's not our legal obligation. When clinicians say this would be best for the child, the school district reads that recommendation as, well, that's an option that might optimize the child's performance. But again, we're not obligated to optimize performance. We're only obligated to provide services that are necessary. Some of you may have heard about the Rowley standard, which basically said provide what's necessary, and then was overruled ostensibly by a new Supreme Court decision about 5-6 years ago, the Andrew F. versus Douglas County School District case out of Colorado. The Supreme Court said that actually the Rowley standard isn't demanding enough, and that the school districts are required to provide challenging goals and objectives based on the child's individual circumstances and that are delivered through a quote unquote ambitious program. Now, those are just words. They're very vague words, but they were clearly intended to mean something more than what the Rowley case said. And so that's another reason, by the way, to support looking at the child's IEP, because frequently the goals are written in a way that's either too high or too low for the child. And because it's too high or too low, it's more likely that the child is not going to make appropriate progress. And so you can really be very helpful in making the case for goals that are reasonably titrated to where the child is actually at. But challenging, by the way, is very important. This is my own personal definition. It's not legally supported yet, but challenging means that it's at the outer end of what we think a child can do, not beyond what a child can do, but not easy, not routine, not predictable, but in the gray zone of what we are pretty confident the child can do and what we're pretty confident they can't do. So challenging means more than easy. Challenging means more than predictable. On the other hand, there's lots of strategy to writing goals depending on what placement it is. So if you want to show a child's making progress, then there might also be a case for saying you don't ask for goals that are quite as challenging. And if you want to show that a particular program is not particularly good for a kid, you might be advocating for even more challenging goals. Recommendations be as specific as possible, except when flexibility is needed. It varies by situation. So for example, I have an evaluator who says to me, well, this child needs to get 30 minutes a day of speech therapy. Well, that might be great, but not only is no public school going to provide 30 minutes of speech therapy, there probably is no private school that's going to provide 30 minutes of speech therapy a day either. And unless you can come up with a really powerful basis for why this particular child absolutely needs 30 minutes a day of speech therapy, you might actually gum up the works. And a school might even say to let's say you're trying to get a kid into a private placement. They say, well, the private placement can't do the things that you're recommending either. So we're going to stick with the public school program. So try to, I would say, be as specific as possible, but don't over ask. For example, if you say the child needs social work services, okay, great, the child needs social work services, but you don't say how many minutes. CPS for a long time, Chicago Public Schools, for a long time had a rubric, and the rubric provided for kids to get 11 minutes of social work services a week. Now, I don't know if you can even get a kid to sit down, say hello, and play a short game before they're getting ready to leave in 11 minutes. That was insane. But unless you're providing a recommendation that says the kid needs a minimum of 30 minutes, 45 minutes, whatever, or even they need it several times a week, that's not going to be something they're going to be accountable for. If you say a child needs individual versus group, but just leave it vague, they can meet your recommendation without that specificity. If you say a child needs both individual and group, and here are the reasons why, that's very helpful. And so those types of recommendations with detail are important. And again, avoid using words like best, optimal, desirable, may be helpful, may benefit from, unless you intend for something to be conditional. So as an example of that, maybe there's an augmentative communication device that's the $20,000 device that would be really great, but there's an augmentative communication device that you know of that only costs $5,000, and that'll do the job. Recommend, it would be great to have the 20,000 one, but the kid absolutely needs the 5,000 one. And so you can defend your recommendation. Methodology, obviously, I've already indicated the special ed law requires that programming provided by the schools should be research-based to the extent practicable. I'm not sure that there is actually research on every intervention that schools provide, but the more that you can identify recommendations that have a research basis and provide that research basis, the better. And generally speaking, schools don't provide, and in my opinion, frequently don't have knowledge of the research base for what they're offering, oftentimes because the research doesn't support what they're offering as being particularly efficacious for the child. So this is helpful in both informing the educators and informing the parents and their advocates in ways that can help them to improve the likelihood that the child gets the intervention that they actually need. All right, other clinical services, specific recommendations that you make don't ensure that the school will adopt the recommendation automatically, but vague recommendations are generally going to be ignored or minimized. Please provide the setting. If you say that a child has attentional problems, they'll say, okay, we'll provide the child a quiet room, but you don't address the fact that the hallway is noisy. The child gets overstimulated in the lunchroom, in the cafeteria, in the playground, in the auditorium. The child needs few transitions, etc. The more specific you can be about setting, the more helpful that will be in providing guidance to the school and support for the parents. Transition services are required from 14 and a half on. They're supposed to address the child's ability to function as independently as possible post-graduation. And by the way, graduation normally is at the end of 12th grade, but kids with disabilities can be served all the way through the academic year in which they turn 22, and they don't necessarily have to be attending public school to continue to qualify for transition services. And they can qualify for transition services beyond 12th grade even if they've met all of the graduation requirements, if they still have IEP needs that haven't been met. Be sure to identify alternatives, pro and con, avoid conclusions or recommendations that you can't support, identify limitations on the scope of assessment and what the reasons were for that. Don't downplay, but don't overcommit or over-recommend it, or that are beyond your expertise, and avoid declarative statements unless you're confident of the declaration. And certainly in the context of discipline, you're often going to be asked to assess, is the student a danger to self or others? And as much as possible, we need that information, but we also need what are the appropriate settings for the child to be educated in, regardless of that outcome. Spell out accommodations. Accommodations are ways to work around a child's disability. They're not services. And it's important, if you have an accommodation, for example, to learn how to organize your work, that can be assisted with a graphic organizer, but they need to be taught how to use the graphic organizer. So you got to have goals. If there's an attentional problem, there ought to be a goal that the child will learn to self-monitor and self-regulate the circumstances where they seem to be lacking focus or not attending to the task. Holistic recommendations should be provided that address the child's needs and address the reasonable interaction between what's happening outside of school and in school. And you can get more information from our website, mattcohenassociates.com. There are still copies available of the book that I published on advocacy that was published in 2009. And you can email me at matt@mattcohenassociates.com. Okay, so with that, that takes us to the end, right? Almost, I guess, a little bit over 90 minutes. And I'm happy to stay on to respond to questions if folks have questions, or you can email me questions if you'd like. And the chat room has space for questions. I'm not seeing the Q&A opening for some reason. Linda, I'm not going to talk about the Loper decision because that's not really specific to what the clinicians are dealing with at the moment. Other questions? Let's see.
Matt, I put a question in there. It's Mo Booty.
Mo, Jennifer asked, so let me just, Jennifer, you should be able to unmute.
Thank you. I really hate typing, so I just wanted to just talk. Thank you for all of this. I'm sorry I was a little late to this, but yeah, there was a lot, and I agree with so much of what you said. Well, everything as what you said, except for maybe something that is a little bit harder for New York City. That's where I am, and New York City acts different from the rest of New York State, and so like I noticed that their hearing officers like it when you actually say, give this child this much stuff, you know, for this many years or like these many hours. They do like that. Yeah. And so having said that, I was wondering if I could ask this question because I'm not an attorney and I don't do impartial hearings. I usually will refer I'm an advocate. And so I'll do the process of the whole IEP process with my clients. And then if I find that the student could still stay in public school, but has been wronged for X number of years, and so they didn't make appropriate progress and according to their unique strengths, then I would like to see if an evaluator could evaluate the child and recommend services for the child. But then when you recommend services for the child, it's always looking as if like, you know, this child needs 3 times a week of speech for 30 minutes per week to work on the stuff that I just told you in the evaluation that is needed. However, if you're if the parent's goal and my goal is to try to create an evaluation that could answer to the needs of the IEP, the next IEP meeting that's going to come up, but then also answer to the needs of a due process complaint that I would also like the parents to file so that they can have compensatory services. How would you advise me or the evaluator to tackle that?
Well, I think that the need for services in the moment is related to, but not the same as the need for compensatory services. I would say for evaluators generally, compensatory services typically only get addressed in the context of a due process hearing or litigation. They're generally not something that are easily obtainable in the context of an IEP or 504 meeting. So I would try to identify as discrete recommendations. This is what I found about what the child needs at the moment, and this is what I found about what the child was not getting or lost in the past. Here are my recommendations for what the child needs right now. And if there's a need to make up for what was lost, here's my recommendation for what would be necessary for what's lost. In many instances, in my mind, because sometimes you can give compensatory services in the form of 30 minutes extra speech a week or whatever, but oftentimes the compensatory services overlap with what the child's need is today. So if we need intensive therapy today, well, they're going to get intensive therapy today. Is it going to be efficacious for them to have 150% of intensive services as opposed to 100% of intensive services? Or is that going to be overkill and the kid's going to be exhausted and unable to absorb it anyway? So I would try to be aware of those as relevant. Both of those are relevant referral questions for the clinician. And as I said, they overlap, but the more that they can be identified distinctly, the better. All right, Mo, you had a question?
Yeah, I put in there when we were talking about the evaluation language, done in the language that is most appropriate for them. So when we think of the world of AAC, it's actually considered a language, right?
Yeah.
So how do we address that? Because in no school district have I ever, the second a child walks in with an AAC device, they're going to get like a pretty intellectual impairment because the evaluators are not skilled in AAC, like psychologists, or they say it changes the efficacy of the assessment. So basically you have no verbal words, you're now going to be intellectually impaired.
So that's a really tough situation. I've encountered it often.
Yeah.
In all of my experience, I think the kids who are nonverbal are among the most difficult to evaluate.
Mhm.
And if you go back to the language of the IDEA in relation to the requirement that the evaluation needs to be done in the language and mode of the child and that are likely to result in accurate results, I think the fight is that the methods that the school is using are not likely to result in an accurate result. And it requires some pretty creative activity on the part of the clinician, whether it's a school or private clinician. It may require different tests. For example, you can use a nonverbal IQ test as opposed to a verbal IQ test. That could be of some value. You may have to engage in some very structured observation and choice activities that allow you to identify that the child starting with has receptive language, even if they don't have expressive language, and they're able to, if they use eye gaze or they use pointing or whatever the mode of communication that they have is, that they're able to understand the direction, they're able to understand the question, they're able to make a choice, whether it's from a field of 2 or 4, they're able to provide words and so on. So it's highly likely that you're going to have trouble using standardized tests under those circumstances. But that creates, in my mind, an argument that just as the school says, well, this kid isn't testable, but they're saying actually they did test and they ended up with a result that wasn't accurate. The position should be what you did wasn't accurate. Maybe it's hard to use any easily identified common test to do it. So we have to rely on what evidence we do have about the child that's anecdotal or observational. And all of the science is based on data. Data comes from lots of different sources.
Yeah, right.
And so you can get observational data, and if that's the best you have, that's the best you have, but it's still data.
Yeah. All right, thanks.
Okay, other questions?
I popped one in the chat, but I can verbalize it if it's easier, which is just, I'm thinking about your idea that the treating clinician and the evaluator should ideally be different. And I completely understand where you're coming from with that recommendation. But what popped into my head is that I tend to work with a population that take a very long time to build trust and rapport and are not really going to show a fresh evaluator almost anything. I mean, like full work refusal, whereas like I could get them to go through the testing. So I'm wondering, how do you balance that idea of wanting to show, from kind of a strengths-based perspective, wanting to show what these children can really be capable of in a trusting environment, with wanting to maintain that objective and neutral stance. It's complicated in the sense that I know a lot of clinicians will have me do evaluate my own clients because they're not going to work with someone they don't know well.
So Courtney, in some ways, I think your question is the same question as the question that Mo just asked, just in relation to a different element of the impediments to communication. I actually had, just to give a further reflection on this that's absolutely in tune with what you're saying. And by the way, I was describing ideally evaluator and therapist should be different, but circumstances may require someone to do exactly what you did. I'll give you a similar example. I once had worked in a situation where the child was an African-American teenage boy, and he'd been in various ways abused psychologically, at least, and perhaps physically by white staff in school settings. And so whatever the normal tensions might be in terms of white-black interaction for a kid and an educator, he had even more specific and legitimate reasons to be distrustful of the therapist, who was white. And the therapist wrote a goal that said that the boy would develop a trusting relationship with her. And I said, wait. That's completely unfair and unrealistic. It's not his job to develop a trusting relationship with you. It's your job to figure out a way to develop a rapport with him. And so I would say, and you're nodding, I think that reflects a similar sort of, if you're the person who's the one who's going to be able to get a good result when other people aren't, then all power to you. That's what you need to do. I would just suggest that that's still something that you might note in the report as something that is understood. But by the way, there's, I don't know that there's, and maybe there isn't, I just don't know about it, but I'm not sure if there's something that says that there is an inherent flaw in a clinician testing a child that they've also done therapy with in terms of the validity of the results. The concern about therapist clinician, in my mind, is more about what happens after you've done an evaluation and then you go back to being the therapist again. And that's pretty dicey. So unless there's some suspicion that you're going to end up with bad results, I would say you don't even need to have a disclaimer. But any non-standard situation, whatever it is, ought to be disclosed and explained. But it doesn't automatically mean that it's wrong for you to do what you're doing. As another example, it's not uncommon for me to have an evaluator say that under the rules of the test, we were supposed to score at this point and stop, but it was clear to me that with additional time, this child was able to continue to answer questions accurately as long as it was no longer timed. Well, if the clinician gave that score without acknowledging that they went outside the protocol for how much time was involved, it would actually be a dishonest and invalid result. But you give the score that was within the time, but then you say, but untimed, the child was able to answer twice as many questions. That's still very useful data, and it helps understand the child in a different way. So be careful about how you explain what you're doing that's non-standard, but doesn't mean you can't be responsive to the individual circumstance.
And Matt, wouldn't it be fair, if you're using it for educational reasons, that you almost want both to show that there's a huge discrepancy? I want someone in the school, because usually the school psychs, they don't know the kids, right? That's the first time they're meeting them. And then and then having like the clinician do, it would be just, I think that would give so much information, because if you're doing the assessment and you're, like you said, you're able to get the child to like go through the whole, let's say, academic battery of assessments, and it looks like they're super high functioning academically, but then if the school psych did it, who has no idea who this child is, they're going to score super low. But that might be the reality in school. So we need to somehow figure out that discrepancy. And I think it would just be so informative.
I think that's important. I agree. This also goes back to the example I gave in the middle of the presentation about the kid who did terribly on the standardized test, but then was texting with his brother about where they were going to go for lunch. So I think that, another way to say all of this is, I think good clinical work can't ignore the rules of testing, but they also require being holistic and using common sense. It's just then a question of being honest and disclosing whatever the deviations or choices to work outside of the normal format or the normal rules. Okay, any other questions? Comments?
Just quickly, I just want to say that this was a very helpful and informative meeting, but I just want to weigh in quickly about some of those concerns. Again, Matt, you said it earlier, you have to do a thorough evaluation. You have to look at all the different possible issues that could be happening with a child, and that should bring you to the right conclusion as far as ability levels and things like that, triangulation of data. But a good, strong clinician should be able to tease out all of those issues.
I agree, absolutely. Unfortunately, I don't have as much confidence in school evaluations, in part, not just as a question of competence, but as a question of caseload and time and external pressure from the administration in terms of the result that they want. But I have to say, I deal with generally, I'm in the Chicago area, work with a lot of really great clinicians who do, including you, Mary Beth, a really good job of that broad and thoughtful evaluation. I also get some evaluations that are absolutely appalling and cost a lot of money. And actually, the other thing to say is, and here's where the therapist and clinician part also raise a concern. There are a number of clinicians where I get recommendations almost without fail. They say, and we strongly recommend a neurofeedback program, and our office just happens to provide it. And so here you can sign up, or 18 sessions at $200 a session for neurofeedback. I'm using that as an example, but a lot of variation in both competence and sadly ethics, I would say. Missy
Good point.
Alexander,
Okay, fair enough.
What? I'm sorry, what?
Fair enough. Okay.
And actually, because there are a number of advocates on the call along with clinicians, I find it enormously helpful to have a dialogue with clinicians, often before the testing, but certainly after the testing. I never tell clinicians, this is what you should say. I'm not a clinician. I don't have any basis to challenge your findings or your conclusions, but I can ask questions like, here are some things that we were concerned about that I don't think you addressed. Is there a reason for that? And if there wasn't a reason for it, or even if there was, can you go back and address them? Gee, I don't see rating scales from school staff. Is there a reason you didn't include rating scales? Is that something you can do? Gee, you said that it would be best for Matt to be in a therapeutic day school, but you didn't really provide reasons for why Matt needed to be in a therapeutic day school. Were you saying that that was just an option that might be nice? Or were you saying that Matt really needed to be in a therapeutic day school, and here are the reasons why? So I think as advocates, those of you who are on the call as advocates, there's nothing wrong with having interaction. Though be clear, you're not telling a clinician what to say ever. And hopefully it's a learning experience in both directions. And the clinician can help to inform you as the advocate, and you can help to inform the clinician about how what they say will be the most effective. All right, any other questions? I've got a person on the call who I'm going to specifically invite Missy, do you have any comments about this as a very well-informed advocate?
Well, I'm blushing getting that compliment from you. No, I don't, Matt. I concur with everything that you said, and it's such a sticky wicket sometimes with evaluators, but just if you believe that the child needs something, don't take no for an answer.
Well, another way to say what you just said, Missy, that I think is very important is, and I say this to parents, follow your gut. If you feel
Yes.
something's not working, you're not just taking drugs, imagining things. Usually, if parents may not understand what's wrong or what the solution is, but the instinct that there's every once in a while, I get a parent who's, a micromanager, a helicopter parent. They're worrying about everything. Kid has an anxiety disorder. You can see in an instant where that anxiety disorder comes from or whatever. But 90+% of the time, 95% of the time, even if the parent can't articulate at a diagnostic level what's wrong, they have a very good basis to say there's something wrong, and often in a fairly detailed way. And it's not uncommon for that matter for the parents to be very good researchers, and they come up with really good ideas. On the other hand, I often have parents who they've gone on the internet, and on this chat site they were on, there's now this miracle cure, and they're going to spend thousands of dollars on a miracle cure that has no research supporting it. So clinicians can also be helpful in kind of helping parents to develop a realistic sense. And I'm sure we've all had the experience too of families who are just having trouble accepting their child has a disability, and both the clinician and the advocate can help them to work through their confusion and frustration and even grief about the fact that their child is going to have struggles as they go along. Okay, and another one I'm going to invite here is Jeffrey Katz. Any thoughts or comments since we're
No, thank you, Matt. I thought it was very, very helpful, very interesting. And it's always good to hear, kind of your perspective, which is a very good perspective of what's going on. I remember you saying one time that I think I heard it from you that if the school doesn't want to do a 504, it's still part of federal law. And that I've raised that before that, whether or not the OCR is no longer going to be there, but it's there and it's in the law and you're expected to follow it. So that's one thing that I remember. Another thought of mine in my work with the school is that it's always good to find somebody in the school system that has an understanding of ADHD. I don't know about other areas in Virginia Beach where I am, Virginia. There is a person who's the instructional specialist for Section 504, and her job is really to make sure that the school district is complying with it. And I can call her into a meeting pretty easily so that she can back up many of the things that I'm recommending. Yeah, so on the evaluation side, I was looking at this thing here about balancing wanting to be strength-based. You should an evaluator do the evaluation, or if some of the therapists should they do the evaluation. I am cautious about doing that, but I do it when I know what needs to be done, and work very hard to separate that out necessarily from therapy, but to be able to be as clear as I can be about what I find with the testing.
good? Well,
Yeah.
just to respond to your first point, I didn't mean to say that 504 has no utility. I'm simply saying that OCR has very little utility.
Yes, I understand that.
There
Yes.
is a right to request a hearing from the school district under 504. And in fact, though I haven't done a huge number of 504 cases in contrast to special ed cases, I've won every 504 hearing I've ever conducted. And that's
Yeah.
despite the fact that the school district gets to appoint the hearing officer, whereas under the IDEA, generally the state appoints the hearing officer. So there's still remedies that are available under 504 for a parent and potentially even without an attorney involved. There is also the potential to go to court under 504, the Americans with Disabilities Act. And as folks are aware, to our surprise, the Supreme Court just a few days ago came out with a new decision indicating that the standard of proof for violations of 504 ADA was lower than it had been based on a number of court decisions in recent years. And so there's going to be, I think, more discussion about and litigation under 504 and ADA because of that. And frankly, I hope, though most cases don't end up in court, it's going to probably involve, 1% of 1% of all kids with disabilities, but that it'll have a motivational effect on school districts to be more careful about their decision making, and perhaps even to strengthen the use and enforcement of 504 as a mechanism to support kids, because that court case involved a non-special ed situation and remedy.
And one other thing I'll say is that I think what you said about as a psychologist who's done a lot of this work, for evaluations and also within the school system. I'm not advocacy. I'm not an advocate. I'm a clinical psychologist. I've gotten very comfortable with saying what I think and what my degree says, which is that I know something about this stuff. And oftentimes the school needs explanations to, for me to impart my knowledge to them about, what this disability is, with ADHD, whether it's a learning disability or whatever the disability is. And I just keep right at that's what they need to be doing. This is what we're talking about. And usually it ends up pretty successful.
Good.
Yeah.
Well, that brings to mind another observation that I had a woman in my office who was an advocate who passed away a couple of years ago, but she worked for me for about 25 years. She was a brilliant woman. She had a high school education. She had a kid with a disability, and she knew the IEP process better than most of the attorneys who I knew. And she loved going to IEP meetings. I have to say, I hate going to IEP meetings. I go, but I hate it. And I hate it for a very specific reason. And that is that I get so damn angry at being at this meeting with professionals, some of whom have been teaching or been administrators for several decades, and they still don't know some of this stuff, or I actually think some of them don't know. And some of them do know and are choosing to ignore or avoid, and that's reprehensible. And some of them don't know. And how can you be doing a profession and after years and years and years, you still aren't understanding? And so I end up, in effect, and this is maybe a comment to all of the folks on the call, don't assume people know, don't insult them, but don't assume they know, and be prepared to explain in a respectful way what the law says, what clinical diagnoses mean, and we've got Mo Booty, one of the great special ed advocates of Chicago, on the line. But Mo, I don't know if you'll agree or not, but in my experience, it's very common that the IEP team doesn't even know all the things that their own district has available. And so sometimes we have in Chicago a whole extra strata of management called district representatives, who are sort of the real power behind decision making.
Right.
But oftentimes the IEP team is clueless about particular interventions or schools that are available or whatever, and sometimes clueless as to what the law says. And so you have to educate them, and hopefully that can be done without conflict. But I've been doing this a long time, and it feels like I'm still doing the same lessons now that I was doing 20 or 30 years ago. All right, I think on that happy note, and I got a thumbs up from Mo, unless there's any last comment, I think we can call it a day. And thanks for all of you sticking on for a bit longer. All right, take care. And Mary Beth, are you now open for? Okay, good.
Yeah, I'm very excited. Mo and I have Mo and I have worked together on a bunch of occasions, and I just want to tell you, we had a lot of fun putting together a document for an IEPT once about what a SMART goal was.
Yeah. And that was in 2025.
And what's amazing is that SMART goals aren't unique to special ed.
No,
They're
no.
common parlance.
Boy. Yeah.
All right. Well,
Yes, I am, Matt. I will be in touch, okay?
good. All right. Take care, everybody.
Thank you.
Thank you.